The meeting of the Public Safety Committee is now called to order. Mr. Clerk, would you please call the roll?
Alderman Bosley, Alderman Schmidt.
Here.
Alderman Boyd.
Present.
Vice Chairman French.
Present.
Alderman Vaccaro.
Present.
Alderman Arnowitz.
Present.
Alderwoman Hubbard.
Present.
Alderman Carter.
Present.
Alderwoman Ingracia. Alderwoman Green. Chairman Kennedy.
Here.
8 present. We have a quorum.
Okay, thank you. We do still have before us Board Bill 208. Some of our committee members had asked to have a representative from the Police Association to address the committee so we can ask questions. And their representative is here. We'll take that first. And then any questions we may have of the coalition that has been pushing this measure, we'll also give an opportunity to ask them any questions as well. I don't see the individual. Where is it?
Task officer.
The association.
Oh. I think he's being interviewed.
He's out. Here he comes. We were just major intros. Just please come forward and identify yourself. You have about...
Good morning. My name is Neil Bruntrager. I am General Counsel for the St. Louis Police Officers Association. Mr. Chair, thank you for the opportunity to address this committee. There is some information that I have provided to members of the committee where I've attempted to overlay the various bills, including the original bill, the substitute bill, and what I would describe as the POA suggestion.
Have any copies of that with you now?
I don't have hard copies. My understanding is that we had forwarded them.
We emailed them, but it was just asking.
Yes, sir.
Okay.
My secretary's printing them off. Do you want me to make extra copies?
Yes.
Okay.
You never got it. Well, there's some technical issues here, but go right ahead. And the committee wanted to hear from you and then have the opportunity to ask you questions.
Yes, sir.
So that's primarily why.
Yes,
So if you can go forward.
It might behoove us, however, if everyone doesn't have copies of what I've sent, to actually have those going forward, because I was going to make reference to those as we went through the discussion. And perhaps it might, if she's running copies, it might be useful to do that. But again, I'm here at your pleasure, so.
Well, let's hold on. Okay. If you're going to reference that, we could. Someone is making, our clerk did not get a copy.
I'm sorry about that, sir. I apologize. We can make copies and get it to him.
I gave him the copy I had, and he's over making copies right now. Because mine
Okay.
opened from, well, I opened it under a different program.
In the meantime, Mr. Chair, there's a few preliminary remarks
If
that
you
I
would.
could make.
Go
I want
for
to
it.
make sure that the committee understands that I'm here, obviously, on behalf of the Police Officers Association. I want to clear up any misconceptions that the Police Officers Association stands opposed to the idea of civilian review. We do not. The idea is embodied in statute. It has been created in 2004. It is the law of the state of Missouri, and obviously we are an organization that's designed to uphold the laws. We do not oppose the creation of a civilian review board, but we think there's a context in which you have to consider the creation of a civilian review board. For your purposes, you have to consider, of course, the enabling statutes that gave local control. It is my belief that local control would not exist today were it not for the collaborative efforts of the St. Louis Metropolitan Police Department and its association. We sat down at the table and we negotiated the terms and conditions under which local control should be enacted and the statutory authority for that. In the statutory authority, it talks about a very important issue. We call that our investigative rights issue. We also have, as an association, and we consider ourselves, by the way, as an association, primarily a labor organization. We hold a seat on the Labor Council. We consider ourselves and the things that we do important regarding the labor terms and conditions. And again, for our purposes, we have always attempted to collaborate in the creation of important legislation, and we would like to do that here, which is why we've asked for this time. The statutes that you have to look at are 84.344 and 341, which are the enabling statutes. You also, of course, in the body of your bill, have made reference to Section 590.653, and that is the section on civilian review. Additionally, you have to consider the collective bargaining agreement that the Police Officers Association has with the City of St. Louis. All of those things are things that create the context in which you are creating this thing called the Civilian Oversight Board, what I have referred to as the Civilian Review Board. We have followed, when you get copies, you will see that we have multiple pages. What we've tried to do is compare each of the bills, your original bill, the substitute bill, and our suggestion. I think what you will find is that there are a number of areas, in fact, most areas, the vast majority of areas, we agree completely with what has been suggested in terms of the bill. And we want to identify those areas where we agree, and of course, those areas where we disagree. I don't know where we are in copies, but it would be my...
It's going to take a while because there's so many multiple pages.
There are multiple pages. So let me start by saying in the very beginning, as we overlap these, the section that deals with the establishment of the board, obviously we have no objection to that. That's state law. You've cited state law. We agree with state law. As we look on page 1, in terms of the first page, there would be nothing that we disagree with. We don't run into any disagreements until we get to Section E of the original bill and Section E of the substitute bill. And the thing that we disagree with there is that you have a provision that says that the board shall exist for the purpose of investigating complaints involving excessive use of force, abuse of authority, sexual harassment and assault, discourtesy, racial profiling, or the use of offensive language, including but not limited to slurs relating to race, ethnicity, religion, gender, sexual orientation, gender identity, and immigrant status. In our suggestion, we have followed exactly the language of the Civilian Review Statute, which says that the Civilian Review Board has the power to investigate excessive use of force, abuse of authority, sexual harassment and assault, discourtesy, and the use of offensive language, including but not limited to racial slurs. And then it goes on to talk about race, ethnicity, religion, gender, and sexual orientation and disability. The only difference is the use of the phrase racial profiling. Now, that doesn't mean that a board who is designed to look at complaints against officers can't come to conclusions about racial profiling. You can. But you've used the language, or you're citing the language in Section E as though that were the statutory provision. The statutory language does not include the phrase racial profiling. So we have eliminated that solely because it's not in the language of 590.653. Again, do you get to that? Yes, and if you look later in our bill, those sorts of things are covered in the bill. In our own provisions, we also say, and we add this language, all requests shall be in writing and sworn and attested to by the citizens making the complaint. Now, that is a very, very important part of this. The statute says that any complaints made to a civilian review committee shall be sworn. That's in the language of the statute, all right? Your bill, both the original bill and the substitute bill, have no language to that. It simply says signed or unsigned. So again, the idea that a citizen who comes in and makes a complaint has to be prepared to stand behind their complaint and basically swear to it, attest that it's true. We're asking that that happen because that's what the statute says should happen. So we propose that change in the bill. The next place where we would see a difference is in the area of what we call independent inquiry. In your provision on the bill for independent inquiry in the original, it says that the COB, or independent inquiry means the COB's separately conducted examination of an IAD investigation where the COB may request the attendance of complainants, witnesses, and employees of the police department at interviews, access under reasonable terms physical evidence, and otherwise investigate the circumstances. What we have proposed, again, is language that we think is consistent with the statute, which says independent inquiry shall mean the CRB's separately conducted examination of an IAD investigation. Now, it's our position that you as a board do not have the authority to create a civilian review board or a civilian oversight board that has subpoena power. Subpoena power is something that must be granted specifically by statute. It is not called for at 590.653, and your charter, while it allows for subpoena power for aldermanic committees, It's our interpretation of that particular section of the charter. Our interpretation says that that committee must be a committee that is peopled by members of the Board of Aldermen. So we don't believe that you have an independent subpoena power. So we have eliminated those sections which we think would be sections that you could only carry out with subpoena power. We don't think that there is the authority under either state statute or city charter for that. And so we limit that. Now that, again, doesn't mean that you can't look at all of the evidence, that you can't look at all of the interviews, that you can't review all of those things. We think you can, and later on in the proposals that we make, we address all of those things. You have complete access, in my opinion, to the internal affairs file. You have a complete ability to make recommendations to internal affairs about how they would conduct their examination. You have the ability under what we've suggested and under your original bill to go back and say, we think you need to augment your investigation by doing additional things. We're not eliminating that. What we're doing here is we're addressing the subpoena power in terms of our suggestions. We also, when we get to section K of your definitions, we also eliminate that section which talks about monitor and monitoring. The reason that we do that, and we do this throughout, the reason that we do that is because you have provided in your original bill and in the substitute bill certain provisions that would allow the board itself, the Civilian Review Board or Civilian Oversight Board itself, to actually participate in investigations, to actually sit down, be present when interviews are taking place, actually potentially even involve yourself in the examination of witnesses, although there are provisions that say you cannot. Those limitations don't seem to be clear. So what we've done is we've said that we think that this is a problem because you're now running headlong into the interference statutes that we have. So if you recall when we did local control, there's a provision in there that says that you as a board of aldermen may not interfere in an ongoing investigation at the police department. And it's any investigation. It's not specific to a criminal investigation. It's any investigation. If you're allowed to participate in an interview which is part of an investigation, you at least arguably are now in violation of that statute. So we've eliminated that. Additionally, you're in violation of that section of the collective bargaining agreement and the enabling statute that deals with our investigative rights as an association itself. Talks about what rights we have, what obligations the city has in terms of how they would handle these investigations. So we've eliminated section K because it runs afoul of the investigative rights and because it runs afoul of the interference statutes. When we come over into section 3, which is the oversight, civilian oversight provision itself, we have sought to augment the requirements for those people who would be members of the board. The original suggestion was the age of 18. That created a situation where you might theoretically have a high school senior who could be seated on the board. And again, while they're certainly eligible and able to vote, and I don't quarrel with that at all, are they really individuals who are in a position to make the important decisions that we're asking this board to make? So we simply suggested that it be raised to the age of 21. I understand the substitute bill is 25. Again, I would certainly be happy to see the age of 25. I think we need people with some experience. We need adults who have some history who can sit on this board to make the very important decisions that we've made. The other qualifications that we have suggested that we add to this are qualifications that we apply to police officers. So what we've said is that if we're asking individuals to sit on this board, they ought to meet at least the minimum, the threshold requirements that we ask for someone who is serving as a police officer in the city of St. Louis. So that's why we added in there the educational requirement that you have at least an associate's degree when you're sitting on this board. Now again, there are going to be lots of technical issues. There are going to be lots of legal issues. Does an associate's degree or a bachelor's degree or even a PhD guarantee that you'll understand all those things? No, but we think it helps, and we think that that, again, is a threshold that ought to be met. Additionally, we have applied in section F of our proposal versus your F, we have suggested some additional additions. One of the things that we've talked about, you have provisions that say you cannot be convicted of a state or federal criminal offense which constitutes a felony. We adopt that language. You talk about what a conviction is. It includes a suspended imposition of sentence. We adopt that language. But we then add any conviction for a misdemeanor, which includes sexual assault, domestic violence, or an assault directed against a police officer shall also be grounds for disqualification. Well, why do we do that? Again, there's language in there which we embrace wholeheartedly that says we want to make sure that when people take their seat on this board that they're fair and impartial. Those sorts of offenses may affect your ability to be fair and impartial. We think it's a common sense approach, and again, these are the same standards and limitations that we would apply to police officers. We're simply asking that they be applied to your board. We do not ask for anything beyond what we're demanding of the people, the men and women who are police officers. We also go on to say that we are asking for any person who is applying to this board submit access to all social media sites and identify all names and pseudonyms owned or used by the individual. Now that is, again, a common sense issue. We have to pay attention to social media. In this day and age, when people tweet, when people belong to Facebook organizations, when people are putting online the fact that they like or don't like certain things, that's the sort of thing we would expect anyone who's using due diligence in a background check would look at. So if I'm a member of an organization that says, I believe in the police, I don't care what they do, I could never find a police officer guilty, that's something that the Board of Aldermen, when considering whether to confirm the person, ought to know. It's a two-way street. It's applied uniformly. It is simply asking that when someone applies for this board and we do a background check or you do a confirmation, that we know as much about that person as we can. If I were choosing you to sit on a jury and I have an unusual issue in the case and you have gone on social media and you have taken a position on that unusual issue, can I look at you and say you would be fair and impartial? Maybe, maybe not, but at least it's something that we ought to inquire. Note, I don't say it disqualifies you. I say it's simply something that we ought to be able to do. Now again, this would be something the Board of Aldermen's doing. This is not something the police department's doing. So if we get into privacy issues and say, well, wait a minute, why do you have a right to do that? Because we're asking you to do something very important. Does it infringe upon First Amendment rights? Of course not. You have an absolute right to say whatever you want to say. But might it affect your ability to sit on this board and be fair and impartial? It very well might. And so again, we think as part of a due diligence background check, this ought to be looked at. The next place where I would note a change is under that section. That would be paragraph 6, again, of this. Make sure I'm giving you the title of this same section that we call oversight, paragraph 6, and that's under term of office. What we have also, and we would also ask you to consider the fact that anybody who's sitting on this board is going to be limited by the state statutes regarding sunshine law, what's a closed record, what's an open record, and what can then be made public and what cannot be made public. Neither the original bill nor the substitute bill have any provisions for what happens in the event that a board member were in some way, shape, or form to violate the sunshine law or violate the privacy laws that affect the disclosure of records. What we have said here is, under term of office, that any member of the CRB shall be removed for misconduct arising from the violation of any of the rules regarding the sunshine law, privacy rights, and the handling of records as outlined at the discretion of the mayor of the city of St. Louis. Now, again, someone has to have the authority to move it. I don't care if it's the mayor or the Board of Aldermen who removes, but somebody has to have the authority to remove someone who violates the sunshine laws and the privacy laws. Every officer who works for the city of St. Louis has a presumption of innocence. Everybody in the city has a presumption of innocence. If we are releasing records in violation of the sunshine law, we have to have something that allows, again, either the Board of Aldermen or the mayor of the city of St. Louis to remove the board member who violates the law. You have no language in there in that regard. We have asked that you consider that language. Finally, in that section, we add a paragraph 11. And again, in this paragraph 11, if those are copies, I'll wait until they're distributed.
Oh, yeah.
Are they?
Yeah.
Great, thank you.
Oh, Terrence, before you do that, let me see.
The copies that are being distributed to you are numbered, and if you'll note just the way it's done, I did it on a landscape page We did this over the weekend just to make sure you had something to make reference to. The column on the left is the original bill, and note I've marked it original. The middle column is substitute, and on the far right is the SLPOA suggestion. Okay? I'm on page 11. I'm on page 11. I've tried to highlight those sections where there are changes, so if you don't have a color copy, you might not have the highlights. On page 11, my paragraph 11 on the far right is an addition. And it says, all members of the CRB shall adhere to the same standards of conduct required by the members of the department. So again, are we applying anything there that we're not applying to members of the department? No, we're not. But that includes submission to mandatory drug testing and any conviction of a criminal offense, felony, or misdemeanor while serving on the CRB will cause their immediate removal from the CRB. Those are the same standards that we apply to police officers. Again, not doing anything there other than saying abide by the law. But if you find yourself in a situation where you have not, as a member of the board, and you've been convicted of some offense, that ought to lead to your disqualification from serving on the board. If you look at page 12, my paragraph 3 on the far right, I've added the word unsworn. And again, I'm doing that because that is consistent with what is in the state statute. So again, no finding shall be based upon an unsworn or anonymous complaint. I've also made a slight change at the bottom, and that basically says, in your original proposal, it says, whenever possible, recommendations regarding policy, operations, and procedures should be formulated. What I've said here is all recommendations regarding policy, operations, and procedures should be formulated, and I go on. Now, the reason I do that as opposed to whenever possible is because whenever possible is sort of a phrase that allows people to duck and dodge, both on the part of the board and on the part of the police department. Now, the people that you'll be dealing with, if you are on this board, are not members of the St. Louis Police Officers Association. Your contact with us will be very, very limited. You're going to be dealing with the administration at the police department itself. So any recommendations that you make ought to at least have the opportunity for input. So again, I put all in here because before anything gets released, everything ought to pass between both hands. That, to me, is only fair. And again, that's in keeping with 590.650, which is the statute regarding civilian review boards. The next change that I would make is on page 13 of this document, and I've added the phrase in paragraph 5, records. It says, except the CRB shall not have access to a department employee's personnel file. In section 5, your original provision says, to the extent permitted by law, the COB shall have access to and the ability to obtain copies of all records, policy statements, operational and procedural guidelines, and manuals necessary to perform its function. Now, I've accepted personnel files because your personnel file as a member of the department does not contain any information relevant to internal affairs complaints. It contains background information on the police officer. It contains personal information about their health condition. It would contain things like awards that they've gotten, anything that they may have done that would be a positive. It would contain their employee reviews. That would be supervisors who are looking at them in various ways, shapes, or form. Again, those are things that are used for the decisions about decisions to promote, but those are not used for the purpose of discipline. They have nothing to do with discipline. So the personnel file, and this has been the subject of a great deal of discussion and, in fact, litigation. So anyone who's paid attention over the last several years is aware that we have this thing called the World Series ticket case. That's out there, okay? I represent the police officers involved in that matter and the privacy rights that are at issue there. There are certain things where we think we need to draw lines on because they have nothing to do with internal investigations. The personnel file, if you think that there's any information about internal aspects, there is not. So your personnel file ought not to be included, and as a board, you ought not to have access to that private information. It has nothing to do with complaints, and so we've asked that that be excluded. And we think that's, by the way, in keeping with 84.344, That is, again, the enabling statute that created local control, because in that statute, it specifically says that the Civil Service Commission has the ability to make certain rules regarding discipline. They get to define what the disciplinary records are. Not me, not the POA, not the police department, the Civil Service Commission. This is never part of the civil service record. The next change, and it's by omission rather than anything else, is on page 14. There is reference in your bill, in the original bill and in the substitute bill, where you talk about volunteers. Volunteers, in my opinion, are a true problem as we go forward. Why? Because you have to have the ability to control the disclosure of information. Volunteers are not members of the board. Giving them access to information is going to be violative of the Sunshine Law, and it's going to be violative of the privacy rights of the officers who are involved. Again, I understand that we may want volunteers, and I understand that actual members of the board are volunteers, but to create a subclass like you have done and say we might give volunteers access to private records is a real problem, because what if that volunteer discloses the records? So when I'm looking at Section 8 under Manual and Training, where you have other than a volunteer, do you see that on the far left? Do you see what I'm talking about, Mr. Kennedy? Dead center in the middle. It's in parens.
It doesn't say.
Where?
On page 14, in the middle of your original bill, in paragraph 8, you have a reference to volunteers. Each COB member and staff member other than a volunteer must complete a course. Okay. I just want to make sure everybody's on that same page. And then at the bottom, the last word you hear, again, is volunteers. We should never be giving records to individuals that aren't bound by the oath of office that the board would take. That is a privacy issue. It's a Sunshine Law issue. So again, while we may want volunteers, we can't give them records. If you come over to page 15, again, it's the same thing. You talk, and by the way, you're not providing any training for the volunteers, and that's something that's very, very important, and I'm going to get to here. But again, you talk about each CRB, you talk about the COB may adopt a training program for volunteers that is appropriate in time and substance for the work the volunteer will perform. I think the use of volunteers outside the committee itself is problematic and then in violation of the law. If you look on the far right-hand column now on that same page 15, what we've asked is that no member of the board shall participate in any review until they've completed the training. What you have in your original bill and your substitute bill says that there has to be training, but you could theoretically on day one, you could come in and you could sit down and you could make decisions about a particular case without having had any training. So again, we think this is a common sense change that says you need to be trained before you sit in judgment in these sorts of situations or before you make a recommendation. So that's what we have included here, and we've said that twice. No member shall participate in the review of a complaint, and this is on page 15, top of the page, on the right-hand column. No member shall participate in the review of a complaint until completion of the training. We leave the training to you, but we ask that the training be completed. And at the bottom of that page, or bottom of that paragraph, we again say that you have to do it within 6 months, and you have to do it before you participate in a review. Again, we think that's a common sense approach, and again, I don't know how reasonable people could disagree with that. If you look at page 16, and here we get into a little bit more complicated approach. When we get into page 16, we're talking about what the annual report would include. You in your original bill say, of course, you'll analyze aggregate data derived from the prior year's complaints, and we would expect that. That's what you're supposed to do. We embrace that. We have no problems with that, all right? Section B, to the extent necessary, include recommendations related to police department policies and procedures, racial profiling, and systemic problems. For my purposes, I don't change that. So again, here's where racial profiling comes back in. You can conclude from the information that you have whatever conclusions are supported by the information regarding racial profiling, whether it exists or whether it does not. It's a term of art, however, And the department itself and individuals in the department itself are mandated to create certain documents that relate to traffic stops, street stops, that sort of thing, that are used for compiling that, okay? So it's a term of art. But you as a board should be able to make recommendations. You should be able to analyze and make recommendations in that regard. We don't change that. This is an area where we agree completely with what you're saying. But I changed that in the beginning because racial profiling is not something the statute contemplates. And then when we get to paragraph 12 later, if you'll see my note that says original section 12, I delete paragraph 12 as a separate paragraph on racial profiling because it's already contemplated here. Subsection C I change because, again, I add simply this. We keep the language completely where it says you'll analyze statistics by police district, the number of complaints per officer, and the number of complaints for specific officers. Obviously, you'll have that information, and we'll have to work out ways that those officers are identified. But as to an internal aspect, and that means internal discipline itself, you cannot disclose the names of the officers. And so I've added that phrase without naming such officers. So again, you have an absolute right to do all the things you're talking about. What I'm doing here is simply bolstering the privacy issue and making sure that that's underscored because that is an important part of the statutory scheme and of our collective bargaining agreement. I have eliminated from my proposal your subsection F, which is a report on the COB's community outreach activities. Again, I don't know exactly what the community outreach program would be. There's no definition in the original bill or in the substitute bill in terms of what that would be. But I think that contemplates volunteers. Again, you've heard my concerns about volunteers themselves, and so as a consequence, I did not include that. Again, does that go to the heart of what civilian review is about? It does not. The next significant change, again, is a matter of omission, perhaps more than anything else. Again, on page 17 now, if you look at paragraph 12 on the original bill, that is the racial profiling data. Your original bill says the COB shall review all relevant racial profiling data and statistics compiled by government and private entities and shall use it to help determine if the police department or its employees appear to engage in racial profiling. The problem that you have with that is that it is a roving commission. And what I mean by that is that on all the information that you have available to you, you will be able to analyze the aggregate data and make decisions about what you have. At this point now, you are going beyond the considerations of 590 because you're now creating something that they don't contemplate. You're creating something in this Civilian Oversight Board that was not provided for by statute. What does this mean? What are its limits? Who gets to prepare this? Who gets to determine whether or not there's an appropriate foundation for that information? If you're looking particularly to outside sources, that is truly problematic because we don't know what those sources are. So again, what we're saying here is you have a right to do this. Racial profiling and and the information that you would mine from that is all important to what you do as a civilian review board. But this provides for a much greater examination than the law would allow you. If you look at page 18, what I have done, again, is consistent with what we have suggested before under the section on what is now our paragraph 12 on due process. And under this, it says, unless required by court order, the CRB members, the CRB staff, the Director of Public Safety, and the Police Commissioner shall not make any public or private comments about a complaint that prejudges the outcome of the IAD investigation and CRB review before the CRB completes its inspection and submits its final findings and recommendations. We add one sentence that simply says a violation of this section may cause a member to be removed. Why? Because if you're indicating before a decision has been made or before an investigation is complete that you have already made a decision on that, now what you're saying here is that that person can't be impartial. That person shouldn't be sitting in judgment in a particular case because they prejudged it. Again, we wouldn't let a juror do that. Why would we let a committee that has such important tasks as this do it? If you look over on page, the next change that we have, actually, is on page 22. Now, this is the inspection procedure itself. And under the inspection procedure, what we've done, again, is add a phrase that requires that any complaints be sworn. So we've added, and it's highlighted, although again, it may not be for you, it's that sentence in the center of paragraph 1 that says, "A complaint shall be properly completed and submitted only if it is signed and averred by the complainant." So that's sworn to, that's all. And that's consistent with the statutory provisions. Now, if you'd look over on page 24, the original bill and the substitute bill have this section on monitoring. We have suggested that that ought to be removed because, again, we think that it's outside the scope of your legal authority because it's giving you rights that run afoul of both the enabling statute, the enabling statutes for local control, for our collective bargaining agreement. So we have eliminated that. We do, however, adopt every other part of this bill because we say here, and we agree, that you have a right to review all parts of an investigation. Right now, anytime a police officer comes over to internal affairs, every conversation that is had with a videotape and an audio. You have a right to see that. If you think that that is incomplete, if you think that they being internal affairs, did not complete an investigation, you have a right to request that they do so. You have a right to see all of those things. We're not changing any of that. What we are simply saying is that you as a member of the board, if you are chosen to sit here, can't sit in the interview. I don't let the judge sit in an interview when I have a police officer that's going to be tried and there's an interrogation that's going on. I don't let a judge sit in an interview when there is going to be an individual who's not a police officer in the same spot. I don't let a prosecutor sit in there. So again, what we're doing here and what we're saying here is consistent with what we see all the time in legal conditions. I've adjusted then the numbering. We're recording everything. The extensions that we have in there are provisions that you have to understand that we do have to account for in an internal investigation. If there is a criminal investigation, you have to realize that all of the time frames that you have here will be set back, and you do that in your substitute bill and in your original bill. You allow for that to happen. Basically, what you mandate is that the chief of police would keep you informed as to what's going to happen. And again, that's only fair. You all have a right to know that. But one thing you also have to recognize, and this is another problem that you have with both the original bill and the substitute bill, and that is our new officer-involved shooting protocols. We have a provision that basically says every officer-involved shooting is presumed to be a criminal investigation. Presumed. Big difference. Didn't used to be that way. That was a process that we began looking at and we collaborated on for about a year before it became the rule that we have now. Now, under that particular provision, there is no internal investigation until everything's done. So you have provisions in here that talk about what happens if there's an officer-involved shooting that involves a fatality. You have a special order right now that prescribes how that happens, and you are running in direct conflict with that in terms of the provisions of both the original bill and the substitute bill. So let me explain how. Anytime there's an officer-involved shooting, the presumption again is that it's a criminal activity. That means that a police officer who's involved in the shooting is presumed to be a criminal suspect. That defines what happens with records. Any statements that are made voluntarily to the investigators in that, and there's an officer-involved shooting investigative team, any statements that are made to them are public record ultimately, not during the investigation itself, but ultimately they become a matter of public record. The idea is to make completed investigations transparent. So the idea here is when it's all said and done, you're going to find out everything that was considered in deciding whether or not it was an appropriate use of force. But what you've done here, again, by involving yourselves in the process, making yourselves present when interviews are taking place, or deferring it to the Attorney General's office, you have now compromised that rule. The other thing that I will tell you is that under no circumstances will the Attorney General's office, in my opinion, agree to participate in an internal affairs investigation. They're not going to do it. Why? Because they are the chief law enforcement officer in the state. If they have involved themselves in an investigative process, they have now disqualified themselves from prosecuting that case. You can't do both. You may or may not know this, and I'll give you a 2-second or 2-minute primer on how internal affairs works, but there are 2 investigations when there's potential criminal activity. One is a criminal investigation, and the other is the internal investigation. The criminal investigation shares all of their information with the internal investigation. The internal investigation does not. Why? Because under the terms of Garrity versus New Jersey, I, as a member of the department, can be compelled to make a statement. In violation of my Fifth Amendment rights, I can be compelled to make a statement. And that statement can be used to discipline me. But that's all. And Garrity versus New Jersey says that's all. It may not be used for the purposes of a criminal investigation. So we have a wall that is a one-way wall. All the criminal to internal, none of the internal to criminal. And in most instances, the internal investigation doesn't begin until the criminal investigation has been completed. If you involve the Attorney General's office or try to involve the Attorney General's office, you put them in a position where you compromise their ability to do either. And we address that. Everything else we think is appropriate, and we keep the same. On page 29, I've highlighted some numbers on the right-hand column. All I'm doing there is simply adjusting the count. That's all. On page 31, that is the section that you have in your original bill, sir, that talks about what happens in terms of the assignment of the internal matter to the Attorney General's office. There's simply no way to do that, again, for the purposes of internal investigation without compromising their ability to make decisions regarding criminal prosecutions. And so paragraph 15 of the original bill, in my opinion, is creating problems that simply can't be overcome. Now, I will tell you, for those of you who are not familiar with the officer-involved shooting protocols, one of the things that happens in every officer-involved shooting, so not just fatalities, but every officer-involved shooting now, is that a file is prepared, it is then taken to the circuit attorney's office for review. So there is a review outside the department of everything that's gone on in terms of the investigation itself, and we have 3 of them that are over there right now. On page 32, we get in again to the oversight section. There are no suggested changes on pages 32 or 33. There are no changes on 34. On 35, we do suggest changes in paragraph 5 on page 35, and that would be under the section of confidentiality. Again, you appropriately go through and list the state statutes that control the disclosure of information. What we have done in an effort to be consistent with the earlier parts of the bill is we have said in here, where we've highlighted, any CRB member who engages in such unlawful disclosures shall be subject to removal as set forth in the rules and regulations of the CRB and the Missouri statutes. So all we've tried to do is give some teeth to someone who might decide that they're going to give up a record, that they're going to put it out there. We're going to find it in the newspapers. Again, that shouldn't be happening. Sunshine Law says no. That's all we're doing here is saying that they may be subject to removal. There could be circumstances where someone in good faith might make a mistake. That would be something I would expect you to take into account in deciding whether to remove them. But this isn't something I would do. It would be something that the board would have to do. Those are the only other changes that we've made. So if you look at those, Mr. Chair, and again, I appreciate the opportunity, particularly at this late date, to be heard on these issues. But what we've tried to do is incorporate some common sense changes that we think reflect fairness. What we're looking for is due process. What we're looking for is a fair process. Nothing more, nothing less. We embrace the ideas. We want to participate in the ideas. We want to collaborate with you and cooperate with you in terms of the implementation of these things. I will tell you, and again, I want to underscore this, most of the contact that you will have will not be with the charged officer. So I would theoretically never appear before that board. I would never be there. I would never speak to them. It's not something that I'm supposed to do. The idea of the Civilian Review Board is that you're supposed to look at these things and you're supposed to make recommendations to the administration so that they can do things better. We applaud that.
Okay, thank you.
Thank you.
Let's take questions from members of the committee. Alderman Schmidt.
Mr. Chairman, there's a lot here to chew on.
Right.
Let me kind of go through these. So on the first change that was proposed on the comparison sheet, page 2, third column, it talks about all requests shall be in writing and sworn and attested to by the citizen making the complaint. First of all, we went through this the other day. I'm not sure that there's a requirement that an individual be a citizen. They could be anybody. And secondly, while there is a provision in 590.653, and I don't have that open right now, but I believe that in order to make a finding, that has to be in writing and sworn. I think later on we'll find that that's actually written in here by Mr. Brunschreger. So part of the issue is to try to make this as simple as possible for the complainant to make the complaint, but obviously in the due process provisions to make sure that we're doing it the right way and complying with state law. So it would seem that at some point in the process, that person would have to, swear or affirm, if they're not able under religious reasons to swear, that they're attesting to this. So I'm not sure that at the very outset that we necessarily want to make that huge hurdle, but we obviously want to take into account the issue that Mr. Brunschreger, I think, raised on behalf of the police and the state law to try to do that. I did notice that, unfortunately, immigrant status is not listed in the enabling statute, although I think it would be a good thing to do. I will also mention that one of my constituents who continues to come after me with a number of recommendations has indicated basic profiling information in terms of looking at those. I know that Mr. Brunschreger talked about racial profiling, but he also mentioned both pedestrian and vehicular sort of profiling, and this constituent of mine is pretty insistent on that if we have an ability to look at that.
And Mr. Schmidt, that information is currently kept. I'm not to interrupt you, but that currently is kept, and that would be accessible, in my opinion, to this board.
On page 3, and obviously this may be something that the committee wants to look at, but from page 2 to page 3, independent inquiry shall mean CRB separately conducted examination. That essentially would be slightly different than what the chairperson has, well, more than slightly, different than what the chairperson has proposed, I think, in that it would simply always be a review of the review. So any IAD investigation, it would simply then, the individuals, and I've talked about this before, that there's various models, and you presented those as well. This is not the Jimmy Carter model of looking and making sure the process is fair, but it's closer to that than obviously subpoena powers or something like that. So without making a value judgment, obviously that it makes a difference. I noted that Mr. Brunschreger talked about eliminating the provision for monitoring. And then he talked about aldermen not being able to interfere with investigations. But at another point, what I heard was that we were talking about not having the subpoena power, or this board not having the subpoena power because they were not aldermen or not within the Board of Aldermen. So my sense logically is that we can't really have it both ways. So if it's not us, then there's not an interference by aldermen in terms of this monitoring. Now, it may not be permissible under some other provision, but it would seem to me logically inconsistent to indicate that it's us and we're interfering if it's not us because we don't have the subpoena power in here. Just an observation. Let me see. I'm going back and forth because it's difficult to kind of go through these, so I tried to circle some of these as well. I mean, I don't know about the age requirements. I know that we would like, and we're asking people to serve on this board, not necessarily because they are, college graduates or have a two-year degree. So I think that's a big decision for us. The important thing is somebody who's fair, impartial, and has enough training and background. And so I'm going to hit this later, what Mr. Brunschweiger talked about in terms of the training. I absolutely agree that they should have that training before they get their first case. I really think that that seems to me, at least from my perspective, to be important. Then there's a provision about any conviction of a misdemeanor, including sexual assault, domestic violence, or an assault directed against a police officer, shall also be grounds for disqualification. I think when we're selecting someone, it would be helpful to know whether they've had run-ins with the police before, because that could reflect on their ability to be impartial. There are probably a ton of people who would have had some sort of assault or issue like that, or could have way back in their history. And I don't know whether that's, I know that the argument is that the person should be equivalent to a police officer. Obviously, these people are not being paid. They do need to be fair and impartial. I'm not sure how far you want to go on that particular road. I know that we certainly didn't want them to be convicted of a felony. It might, and I talked about this earlier, I'm not sure, let's see, I think this is on page 9 that he had it. I'm not sure that we need to put it in 3 or 4 different places, but I think it is helpful at some point to have provisions about removal for misconduct, about privacy rights, sunshine, and all of that. Who does that process? I'm not altogether sure if that should just be the mayor. Mr. Chairman, I think at one point you talked about this oversight board or review board having their own standards of conduct and review. I believe that the alderman from the 21st indicated something about some particular ethics laws. Perhaps there's something in there we would want to specifically outline that process for removing someone, because I think that is important. I don't think we had anything in the original bill dealing with that. Once again, this is on page 11 of his comparison, and I think it's admirable. It would be fantastic and terrific if all of the members of the CRB could be equivalent to police officers in terms of their standards, and I salute the police department, obviously, and our fine officers for meeting that. We may have some issues finding people on the board if they're going to have to submit, I don't know how often, to a mandatory drug testing. Is that an annual thing? Or just at any point that we have a concern about that? I think that could be an issue. On the other hand, I suppose if one's been convicted of a felony and their ability to serve at the outset was prohibited, then if they're convicted during the term, I think that certainly would be something that would be part of that. Here I think it's the point on page 12 where it says, no finding shall be based solely upon an unsworn or anonymous complaint or statement. State law seems to be pretty clear, and Mr. Brunschweiger, who's the attorney here, has pointed that out. So I think that this would probably be sufficient to say that there can't be a finding on an unsworn thing. And then seems to be okay to me to have all recommendations done with a spirit of cooperative problem solving. I think that was your initial intent.
And Mr. Schmid, while you're looking, the averment the sworn matter would just be a matter of, on the form itself, putting there that I make this statement under penalty of perjury. I mean, it's as simple as that. And notarized.
It has to be notarized.
Well, if you actually sign a document that says I make this under penalty of perjury, it doesn't have to be notarized. So again, would it be great if you had it? Most complaints are made by people actually coming in, so we'd have a notary there that was available. You know, again, if you just simply had it on the form, you could do it.
You can.
Okay, so the thing is, I mean, however we work this out, if somebody only has to come in and say, I'm telling the chief when I sign this thing, I think that's one thing. But if they somehow have to come in with a notary, or we put some sort of additional hurdle, one of the things that we're trying to do is to make sure that people don't feel discouraged from making complaints. On the other hand, we also don't want a whole bunch of bogus complaints.
Sure.
And we certainly don't want to have a finding that isn't based on either an affirmed or sworn statement so that it complies with state law. So however we work that. So it was, and I admit that I am not sure, since I've never read a police officer's record or file, what is contained therein. So if there are not past complaints, see, I think it might be helpful if there's somebody, and now they're before the committee, and the employee says, well, I've never done anything like that before, and there's this whole history of, okay, you know, they were warned about it here, and 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 you're talking about what sort of discipline ought to be applied, then it would be helpful to have that record. If, as is indicated, none of that is included, then it would seem to me just to be a fishing expedition and going into the privacy of the police officer to have that.
And I know you're taking my word for that, but in the internal affairs, and you'll learn that once this board is created and the board sits, you'll see what that is. So again, you'll see that there is a printout that's generated that says there's been this complaint, here was the decision. And so that information is kept. But that's not in the personnel file.
Right.
And I think the intent of volunteers was to help on policy areas and gathering things and all of that. On the other hand, I understand why there would need to be a real tight control of that, because I could see down the road somebody forgetting that, hey, they really haven't gone through the training, they haven't gone through any of the requirements, and now they're looking at files and they're doing whatever. So however we deal with that, I think it's valuable to see that there is some concern about this. And again, on page 15, that they have to go through the training before participation in the review. Frankly, I think that there should be once in a while sort of updates, because people can forget and the department can change pretty radically, that it's helpful to have that before looking at any of the data. And again, under paragraph 9, my constituent is very interested on the profiling aspect, not just on racial profiling, but also general profiling and walking and driving stops, which I understand are already available. And without naming the officers, I think that's the intent, is to have the aggregates on that, on not naming the officers, I think, so. I'm not sure, and I know that Mr. Brunstreger would know this better than I. I'm not sure whether looking at profiling data and statistics in order to recommend policy and so forth is a roving commission. But he has indicated that it is. My hope would be that as part of what we've said in terms of working collaboratively, that what we would be doing is trying to figure out those areas of policy change that would reflect our experience from the data. So, and I know I talked to the chairperson a moment ago, and I think We've asked for the city councilor to be involved in these processes for the board when they look at all of these things, and apparently the city councilor has not viewed this as a roving commission.
And Mr. Schmidt, if I may, I want to make sure I clarify that issue. What I've complained about here in terms of how this has been written is that it doesn't define what happens, but the statute has a process that says there'll be a complaint. You investigate a complaint, and at the end of the year, you compile this information, and you analyze that data. I absolutely think you should be looking at that data to determine whether there's racial profiling issues. The department maintains racial profiling information. That should be accessible to you. It's accessible to the Department of Justice. Why would we not give it to our own governmental entities? So again, I think that should. The way this is written, though, it suggests as though you can engage upon an independent investigation of this thing called racial profiling. So again, while racial profiling does have to be considered, I'm not eliminating that. What I'm talking about is how we address it to make sure that it's within the constraints of the statute.
Okay, and just for clarification, Mr. Chairman, hopefully, and I think this is the way you offered it, and at least the way I read it, was that we would look at those data in terms of recommending, because they can't make policy, recommending policy and operational procedural changes that would, so that somehow within this, we would make it clear that what we're expecting this oversight or review board to do is to look at the data and then recommend changes of the.
Based on the data.
And I think that's absolutely within your purview.
Right.
Sorry, I think we're. Okay, I mean, we have a number of areas where there's the whole thing about the signing of the complaint. So there seems to be huge disagreement with regard to the monitoring. That's on page 24. Or what? I'm sorry. On page 24. Obviously, I think there are legitimate concerns about not interfering with the investigation. I guess I wonder, the city councilor has looked at this in terms of actually being present in the room. So this would be that would be a major change in terms of taking out the monitoring. I don't know how you would know if, one of the things I think that the Oversight or Review Board is supposed to do, at least the original version, and even what's being proposed, as Mr. Brunschreger has outlined, is to review the IAD findings. And so if the Oversight Board or Review Board is supposed to look and see whether there's been a full and complete review, I don't know how they would know that if all they rely upon is what is actually given to them. Now, on the other hand, if we're not allowed to do that, that's a whole other thing. But it seems to me that that is one means of determining whether, in fact, there's been a full and complete review of the process, is to be there. But on the other hand, the due process rights of the police and the integrity of the police department need to also be respected. And I thought that was the intent here.
Mr. Schmidt, can I address that for just a moment?
You can go ahead.
Thank you. Sitting in the room while the interrogation is taking place can have a coercive effect on a witness, period. Now, that's all being filmed. It's all being videotaped. So that is going to be communicated to the Civilian Review Board, who's going to look at that. You're not supposed to ask questions while you're in there. You have provisions that say you can't ask questions. So what have you gained by being there, other than perhaps the coercive effect of your presence, one way or another, or what that might mean? So again, you're not accomplishing anything by being there. You're going to get the same tape. You're going to get the same review. You're going to look at all of that information. Why is it essential you be there? And you don't get to be there for everyone. You get to be there only for non-department members. You don't get to be there for the officer who's been charged. So again, you're creating double standards as well. So again, in order to be consistent, that's why I make this recommendation. You really gain nothing. You're still in a position where you get to see it all. You get to review it all. And if you don't like it, if you think it's incomplete, you get to say, go back and do it again, or recommend that. Now, they obviously don't have to do that. You can only recommend. But you're in a position where you can see the flaws, and then if you're going to make a recommendation, if it's flawed, you're able to say, we made this recommendation because these flaws were obvious to us. In the end, you have the last word openly. You can say, we think this was done incorrectly. And then the department has to deal with that criticism, because that's why you're there.
And I respect the whole coercive nature issue. The only reason why I raise that is because I'm not sure how one knows that they have all the tape.
Exactly.
So,
Right.
so there may be a means of doing this where it's outside the presence of that person. I mean, I know they have interrogation where you can look through the window or whatever. My intent certainly would not be to make anything coercive. It could eliminate a number of retakes on this with, I'm just thinking of people that are on the review board or the oversight board that say, hey, we don't think that we've got all the tape. Well, you know what? You had somebody there, and they saw all of this, and it's the same tape of the stuff that you saw. Anyway.
Every one of those tapes, by the way, starts out by saying the time is and the date is, and the people are present and they're visible there. If it is turned off, they announce that they're turning it off and the time is. If it's being turned back on, the time is. Rarely does a tape get turned on and off, but it would be clear from the tape itself whether you've got the whole thing.
Okay, but it's an area of inquiry. I happen to agree that the Attorney General is never going to let the review board or anybody else in that room to do that. But that's my own opinion, and I don't practice law, and he practices law, and our city council practices law. So they would have to tell you whether that's the case or not. It's just my gut reaction. And again, I think there's a number of places where we say we're going to remove the CRB member. I think we could do that in one fell swoop and be done with it. Thank you. I just tried to respond to all of them.
I appreciate it.
And thank you for the...
Thank you.
Alderman Boyd.
Yes, thank you, Mr. Chairman. Good morning.
Morning.
My colleague from the 20th did a very thorough job going through us, so I don't really have a lot of questions anymore. But I did want to ask a curious question. First of all, I want to, for the record, you are speaking on behalf of the St. Louis Police Association, correct?
Yes, sir.
Okay. When we had the commission, do you know what the qualifications were for the Board of Police Commissioners?
Yes, they indicated you had to be, I think, 35 years of age, and you were then appointed by the governor. You had to be a member or a citizen of the city of St. Louis for at least a year, and just in good standing.
Now, are you aware that they had to be drug tested?
I don't know if they were or not as commissioners. I do know, of course, they had to go through the governor's confirmation, or the Senate's confirmation process. Now, whether or not that mandated it or not, I don't know.
But chances are they didn't have to be drug tested.
That would be my guess.
Okay. I'm a little confused as to personnel records and disciplinary records. So you're suggesting, or you're stating that they are totally separate?
Yes, sir.
Okay, and are you also saying that the disciplinary records will be available in this process?
Yes, sir.
Okay. Tell me in what way...
Now, can I throw in there, though?
Sure.
One of the things you're not supposed to do is make decisions about whether or not someone did something based upon prior allegations, one way or another. So again, we all hear the old phrase, where there's smoke, there's fire. That's not what you're supposed to do. Your position on this board, in a quasi-judicial position, is to simply say, I'm going to make my decision based upon these facts. When you get to the recommendation regarding punishment, if you make a decision that someone has in fact violated the rules, when it gets to punishment, is it appropriate then to consider prior complaints that have been made? Yes, sir. And that would be available to you.
Okay, I don't know a whole lot about law, so teach me, if you were defending a client in a criminal matter, they would not allow you to use their prior history in that case?
Right, that's correct.
Okay.
So again, the only time that would happen is if the individual took the witness stand, if I'm representing someone in a trial, and they took the witness stand, the information about their past convictions, which does not include SISs, it includes only those situations where you have actually had a sentence of time or a fine imposed, can be used to impeach your integrity, not to show that you acted in a manner consistent with prior acts, but to show that somehow you're not as believable because those priors have occurred. So under very limited circumstances, it can come in, but for also very limited purposes, and the jury would be instructed, you can't consider this to determine whether or not they're acting consistently with prior bad behavior. That's Law 101.
That didn't make a lot of sense to me.
All right, I'm sorry.
I'm sorry.
That's all right.
Maybe I'm on a cognitive delay response again today, but I didn't get that.
Okay.
Either you can use it or you can't use it.
You-
You say you can
you
use it
can't-
under limited
Yeah.
circumstances.
Right. So again, in terms of the board itself, you would be able to utilize prior information to determine whether or not you think a recommendation for punishment is accurate.
But in a court of law, you suggested that you can use it to discredit
Right.
the credibility of a witness.
Right. But
Okay.
let's say I have 2 prior convictions for driving while intoxicated, okay? And now I've got a third offense that's not a driving while intoxicated offense, all right? If I take the witness stand, those 2 prior offenses that are convictions can be used to test my credibility, whether I'm someone that should be believed. But I can't use them to say, see, he's a bad guy, he's done bad things, and he therefore must have done something bad here. It's a very specific purpose that you want.
Okay. Give me an example of how a member of the board would be in a position to be coercive if they were sitting alongside.
Well, if I'm sitting in the room and there are questions that are being asked, and I'm harumphing, or I'm laughing, or I'm smiling, or I'm winking, or I'm nodding, all of those are ways in which you might be coercive. Or I have an IAD investigator who, for some reason, is concerned about your presence, and he or she adjusts their behavior because you're there. Those are things that would concern me. As a person who represents accused officers, that would concern me a great deal. And I think there's a huge due process problem there.
Okay. The last thing I want to say is just a comment, because I know you're a lawyer. And when you say common sense, it may be common sense to you as a lawyer. It's not always common sense to the layperson. So in a way, I'm just cautioning you, if it would be helpful, you could be offending people by saying it's common sense.
The law in the end is built upon common sense. The idea behind most laws is to...
Trying to help you.
I appreciate that. I appreciate
Okay.
that. Then I'll leave it there.
Thank you.
Okay, thank you. You done, Alderman?
Yeah, thank you.
Alderman French?
Thank you. So we agree upon a lot of things, but there are some things that I think we do disagree about. So in your understanding of how the state authorizes a civilian review board, or in this case, we call it a civilian oversight board, to operate, their only function should be to review the investigations that are conducted by internal affairs, and then just draw conclusions based solely on the review of that investigation?
I think that is the specific statement and spirit of that law. Yes, I do.
So in no way should they be able to do any further investigation or interviews take it upon themselves to do that?
Break that down into 2 parts. In terms of further investigation, yes, if you saw something that you thought needed to be done, or you as a board wanted to be done, you have the right to request that. I agree with that 100%.
So requesting it and them conducting a further investigation are 2 different things.
Right, and that's what the statute says.
Okay. So the statute says that they are authorized to do that and to investigate complaints. And in no way does the statute prevent them from doing any further investigation.
There is nothing in the statute that says you have the ability to conduct an independent investigation, including subpoena power. There's no mention of that whatsoever. It is a review board, and it says that you as a review board have the power to investigate, review, boom, boom, boom. It goes through it, and it uses the word investigate, but you can't parse out one word and say, this means. You have to look at it in its entirety. You have to take these words in context, and in context, it means review.
Yeah, I understand that the state law doesn't specifically say, and the state law doesn't specifically say a lot of things, and especially when it comes to charter cities like the city of St. Louis. The way it typically works is that all rights that the state have flow down to the city unless specifically barred. So I don't think we go through the step on every state law to specifically say what they can and cannot do. It's assumed that by saying that they may, the board shall have the power to receive, and by specifically saying investigate, you would assume that they could investigate, but
But if you're assuming that investigation includes subpoena power, it does not. And there's case law
no,
that talks about that.
that's a separate issue. They ain't gotten the subpoena power
It
yet.
is. It is.
So the first part is whether you believe that a civilian oversight board should be able to investigate.
Well, of course.
Okay. So that would go beyond just review of another agency's or someone else's investigation. They do have the authority under state law to investigate.
Well, they have authority to investigate complaints, and then you have to take all the language together, which means you have the right to review.
Okay. So I appreciate you as an attorney representing your clients.
Thank you.
But we'll disagree about that. So if a civilian oversight board is charged or given the authority to investigate, from your position as representing your clients, why do you oppose subpoena power to conduct a thorough investigation?
Because you're now infringing upon our investigative rights. You're now infringing upon the statutes that create local control, because you don't have the authority to conduct a separate investigation. What you have the authority to do is review.
Conceded that.
No. What you have the authority to do is review what IED has done. You have the right to request additional information, and you have the right to reach conclusions based upon those investigations, including policy recommendations. But in the end, it's review and recommend. Review and recommend. That's what the statute says.
Well, let's pull up the statute.
Okay.
Okay.
That's one of my favorite places.
I know, I love that. All right, so Section 2 of Section 590.653.1. The board shall have the power to receive, investigate, make findings, and recommend disciplinary action upon complaints by members of the public against members of the police department. So when it says that the board shall have the power to investigate, to me, that sounds like they have the power to investigate.
You're looking at that one word, that all of those words have to be read together in order to make sense of that statute.
I read them all together.
But you keep coming back to the one word. And so what I'm saying to you simply is if you look at...
What I agree is that if you go on, it says investigate, make recommendations of disciplinary action. So we agree that they don't have the power to directly discipline.
That's right.
Or to do anything directly to officers.
That's right.
But it does, to me, say that they have the right to investigate and then to make recommendations. And to me, I think it would be, those recommendations would have more meaning if they were able to conduct a thorough investigation before they made the recommendations. So what you wouldn't want is an uninformed recommendation.
Of course.
Okay. And so getting back to the specific question is, why do you oppose being able to get all the information?
I don't. I think you should be able to get all the information, and I think you will get all the information. I think you have the ability to look at the entire file. I think you have the ability to say, you need to do A, B, C, and D. And if they don't, they being the administration, you have the ability to go out and say, we find fault with you in this level. You, in the end, have the last word, because you get to make public your concerns about what wasn't done. And if the idea here, as you've stated, is to build confidence and faith in the department itself, then my guess is they're going to have to listen to what you're recommending in order to make sure that you're working together.
Mm-hmm.
I'm the odd man out here. I represent the individual who's been accused. all right? Now, I have certain rights, and I have certain due process rights, and what you're suggesting is going to bring all of those due process rights into play. You don't address any of that in here. As it's written, I'm the odd man out. But if you engage in your own independent investigations, now we've got to redo everything. We've got to redo the collective bargaining agreement. You've got to look at the legal issues.
And I'll tell you why I disagree, is that all that may come into play if at the end of the day, this new body can discipline officers. But if all they can do is make a recommendation.
No, I disagree. I think that, again, if you're interviewing members of the department themselves, which is one of the things you contemplate you're going to do.
Well, actually, in the existing.
In the original.
As we cannot.
In the original, it says you can't, but in your substitute, it says you can. I don't know what's going to come out. I'm simply saying I'm addressing what's here. So again, if you're able to address department personnel, now I'm not the odd man out. Now I'm representing the individual officer who's been called in front of this board to offer testimony in some way, shape, or form.
Okay, so in the current language before us, in the current version of Board Bill 208, it specifically says the COB may not attend IAD interviews with the police department. It specifically says that they may not interview the accused officer. And anybody else, they can only request. So you, as the attorney for the police union, would you ever allow your clients to be interviewed by this body if they were requested?
Ever's a big word. It would depend. I can't tell you yes or no, because ever's way too big a word.
That's what I would expect from,
You would expect honesty?
From a good attorney. That's right. Okay, so let me just say that I would find it unlikely that you would ever allow any of your clients to be interviewed by this body, even just because of the precedent it may establish.
But, Mr. French, if I may, one of the problems that you have with what you've suggested in that regard is, what if I do? What if I don't bring somebody in? What if you say, I want to hear from Sergeant Michael Fredericks? Is he still here? He's going to be grimacing. What if I hear that, all right, and I say, don't do it? I don't think they have the authority to do it. And we don't come in. Can he be disciplined by the department now?
Not by this board.
Well, but can he be disciplined by the department?
Not based upon anything created in this legislation.
Well, I think he can. And again, that becomes a problem. So again, the legislation that we have that establishes a police department doesn't allow me to discipline an officer for not showing up in court. But if I don't show up in court, I can be disciplined by the department.
But again, this is not a judiciary proceeding here. This is even external from.
If it's
internal
not a
affairs.
judiciary proceeding, then there should never be subpoena power. And
So we're not
that's the
talking
point
about
I've been
subpoena
trying to
power.
make.
What I'm asking you now is, without subpoena power, if there's no authority to force or compel any of your members to ever testify in front of this board, and if they can only, as the current legislation suggests, request, realistically, would you ever allow any of your members to come?
It would really depend, and I'm not trying to dance around that with you, but I will tell you, I've represented policemen for 30 years. There are any number of times when I have sat in an interview room where I think that the person I representing is getting a raw deal, because I think that the administration is treating them poorly. I think they're being unfair. I think they're being petty. I think they're being arbitrary. Under those circumstances, I might come over with an involved member and say, you need to know this. I mean, I've been doing this 30 years. You have no idea how frustrating it's been. And how, when I heard about the idea of civilian review, I didn't oppose it because, frankly, I think it's good having another set of eyes. I do, because it works to everybody's advantage.
Okay, and so, all right, so if the COB cannot directly interview any police officers, there's also this added provision that they cannot even attend the interviews that IAD conducts. And the point you raise is that, you guys don't let prosecutors or judges sit in those interviews. What I would point out, though, is that a prosecutor or a judge does not sit in on those internal affairs interviews because they then have their turn at some point. And in this case, the COB never gets a turn to actually interview those officers.
Right.
So I think that is a big difference.
But again, I think if you look at the stated purpose of the statute, now you and I might disagree on that, sir, but again, the stated purpose is review. And I do think you have input into how that works.
You just keep looking over that word investigate there.
I'm not. I think the investigation contemplates what I've described.
Okay. The additional requirements that you propose placing on members for, who would serve on this board, educational requirements, drug testing requirements. I mean, you realize that, as was pointed out by the Alderman from 22nd, the previous police board didn't have such requirements. In fact, members of this committee don't have such requirements, and we do have subpoena power. So why would...
It's a new day. I'm hoping that we, again, apply the same standards.
Okay. All right. Yeah, I think everything else has pretty much been covered. So, so in general, though, it just seems that without spelling out specifically in the ordinance that the COB would have the right to investigate, or that they would at some point be able to, even voluntarily, but I don't think that's likely, interview the accused officer or members of the police department who may be witnesses to a possible infraction or even criminal act. It goes against what people think a civilian oversight board would do. You know, and so one of the things we want to do is reestablish faith and trust. And we have, we'll set up this new office, put a nice shiny sign out front that says Civilian Oversight Board, bring your complaints to us. And people would assume that they would at least be able to ask the officer, did he do it or not? Or ask the possible witnesses, which may be police department employees, what they saw. And people may even assume that they have the right to discipline officers, which they don't, and under no version here would they. But I just feel like, we risk confusing and misleading the public if we don't give them certain authority. Even what we may disagree, but what I think the state statute authorizes, which is to do a thorough investigation independent of the police department.
And if I may, very briefly in response, it is our task, mine as a representative of the Police Officers Association, and certainly yours as a member of the Board of Aldermen, to educate people on what the law says. It's not a question of expectation, it's a question of law. And under these circumstances, what I've tried to do is point out that these are issues of law. These are legal issues that we cannot ignore. So again, let's make sure that people understand what we can do. We have no problems with what the law says we can do, but it is not a situation where, again, we are creating a separate and independent disciplinary body. I think the suggestions that you've made in your substitute bill do that. And my point is, in the end, if this process works, you have the right to make all of the suggestions that you think are appropriate to Internal Affairs, to the Chief of Police or the Police Commissioner. And again, if they don't follow those, in the end, you have access to all of these cameras and all of these reporters who you can say freely to, we had a problem with an investigation. We thought they needed to interview this person, without giving names, of course, because we got to protect everybody. We think they should have done these things, and they refused to do it. The power of the press then comes into play.
But what you're describing there is to complain publicly. I do that all the time.
I understand. I watch TV.
It doesn't really result in anything happening.
Yeah, I disagree. You're here today because of that. And I think that what we're doing now, which is a good thing, is because of that. So I disagree. I think it does have a value to make a complaint.
And I do want to correct your characterization that the committee substitute or the proposed amendments in any way turn this into a disciplinary body. At the end of every version, the only thing that comes out is a report to the chief and a recommendation to the chief. And the chief is still the chief, so he can do what he wants to do, and I don't think this is going to change his inclinations anyway. But so in no way does it ever discipline officers. And so I just think that if it only can investigate and it can only produce reports, that we should try to make them as well-informed as possible.
And I will tell you, as a man who's been involved in hundreds of internal investigations, the idea that they don't do a thorough investigation is simply not borne out by the facts. If you look at the files, if you look at the information that's gathered, these investigations are thorough, they're contentious, they're adversarial. I find myself in court all the time on these issues. So again, the unfortunate aspect is we've been behind the curtain. We know that, all right? What your board is going to do is bring this out into the open. I'm good with that. I think that that's appropriate. I think there ought to be that transparency, because if people see what goes on, then I think their faith and confidence in the process is restored.
That's all I have.
Alderman Vaccaro?
I don't know that I have questions, I have comments. If you'll take comments now, or if you prefer,
No, we can take your comment.
you'll take them now, okay? And again, they're just comments. but-
These are comments directed upon his testimony? Or
Well,
just,
on the bills, all of them all together.
why don't we we can come back to that then. I was trying to
Okay.
keep it to his testimony.
Okay, yeah.
Okay.
Yeah, because they're not specific to that, but they are specific to a lot of the changes in the bills the way I see it. But not directed directly to him, just comments on whether I feel we should even have a vote or not, and they're general
Okay,
comments.
let's come back to that then.
Okay, I'm
So
fine
we
with that.
just don't have him standing up there. Alderman Ornowitz?
Thank you, Mr. Chairman. So what I'm gathering here and trying to understand, and this is a lot to divulge, we know you're representing the police association, and you're a former police officer?
No, I'm not. I'm a former assistant circuit attorney, and I've been in the private practice of law for 30 years.
Okay. So I know you've been around, been involved in a lot of cases representing police officers.
I've seen one or two.
So it seems like we're all in the same direction, basically, of moving forward. And I think your point is, what you're saying is, we don't have a problem, you welcome a civilian review board. But I think what you're trying to point out is the protection under state statutes, that you can only do so much. And that's being fair if that's what state statutes say. And this is something, we're going forward with, or trying to go forward with, and be fair, and everybody's not going to agree that everything's fair in the long run. So a civilian oversight board, after IAD has done their investigations, so they get everything that the IAD investigated. They can come back and ask questions or whatever they need to know. They feel like they don't have all the information, so they go back to IAD, but they don't have the power to subpoena witnesses, more or less, because you're saying because under the law, the Civilian Oversight Board doesn't have the authority to do that, but they have the authority to go back and ask questions, feel like if they need you to look at something else, not you, but IAD to look at something else, I'm sure they would accommodate them in that aspect.
Yes, sir.
Okay. The age requirements, I think I was amazed we didn't have really a problem with that. The alderman from the 21st even agreed to it, so I respect him for that. But I think, the city, I think there's a lot of distrust for one reason or the other. And there's always going to be that somewhere along the line. And the people you select for the Civilian Review Board, and I'm confident we'll get qualified people that will represent the Oversight Board. I just don't want them to get frustrated as you're going through state statutes and this moves forward, because I think a lot of people's under the impression that once you create a Civilian Oversight Board, that they have the power to be able to subpoena and do other things, and according to state statutes, they don't. So it's something, hopefully, when we get this in place, and you admit and agree that everyone welcomes one.
Yes, sir.
So as this process goes along further and further and further, you know, people gain more trust and start working together, and then maybe other things can happen down the road. That could be a possibility, you know, representing as you do. So, I mean, I just like the point that we're moving a little bit forward now from the original version, which Alderman Kennedy has worked hard on for years. So I think something will get in place. I don't believe it's going to appease everyone, but I think we have to start somewhere and make sure us as a board is not in violation of trying to implement things also, so.
Mr. Arnowitz, if I may, very briefly in response. When local control came into being, and it came into being because the Police Officers Association sat down at the table and collaborated on that and said, look, here's what we think needs to happen. When this came, we knew that civilian review was right around the corner. That's no surprise to us. Again, the old form of the police department represented 150 years, and it had been there 150 years too long. This needs to be a matter of local government. What you're doing now in terms of civilian review is a matter of local government. It's within your power. What I've suggested, I think, embodies the spirit and the intent of the statutes that control.
And I agree with you 100%. And that's basically what I want to say, and just make sure. But thank you for your time. I appreciate it.
Thank you, sir.
Alderwoman Hubbard?
Thank you, Mr. Chairman and members of the committee, and thank you to yourself for coming down. I will say you've done an excellent job of representing the police department, because
Not the department.
well, the union or whatever it is.
I represent men and women who are of the rank of patrolman or below.
Okay. And to myself, it has seemed totally one-sided, and I think that's what we need to work on as a city. And I'm so glad he handled the common sense portion, because I definitely was offended by that.
Well, I apologize. It certainly was not my intention.
Thank you. And, I mean, when you speak to common sense, and maybe you can expound on this, it doesn't make sense to me to suggest that if a person has a SIS, suspended imposition of sentence, that they will be excluded, because technically, once they complete that sentence, it doesn't show up on their record. I mean, you can still see it. It's not closed like it used to be, but to say that a person has made a mistake and it may not have been something serious, to say that they couldn't sit on this board and make fair decisions, I just disagree with that.
Right, and I only adopted that because it was in the original bill and it was also in the substitute, I think.
Okay.
But again, I have no problems with taking an SIS out because it's not a conviction. And again, once you've gone through whatever the probationary period is, it's a closed record.
Exactly.
And I respect closed records. So I would be happy to take that out. I simply was trying to change as little as I could.
Okay. Specifically during a time when, as a city, we've banned the box. So, I mean, that's something to be considered. And in regards to the education requirement, I mean, I know business owners and upright citizens who've been successful in their life, and they simply just didn't go get a formal education. But to suggest that they would need to have an associate's degree, I think that would disproportionately affect a certain group of people, and I think that that's something that I definitely couldn't agree with.
And if I could throw in, I'm certainly willing to trade that in for a certain age because I think experience can overcome education in many instances, and I would agree with you.
Okay. And in regards to the age, I agree that 18 may be too young, but I think it's important to understand that it is good to have a youthful person on that board, because their experience with law enforcement is totally different than even mine or yours would be. So I'm glad that we're not going to go too far out there on the age, because, I mean, if you look at change, most changes came in on the backs of young people. So I think it's important that we keep that in mind. And also to your point on racial profiling, now, correct me if I'm wrong, but the gist of it is that it's not specifically stated in the statute, so that's why you feel it shouldn't be included.
No, ma'am. I do think it should be included, but not as a separate paragraph, the way it is stated in paragraph 12. So if you note, I have included it in a number of different areas because I think those are things that you can reach opinions and conclusions upon as a board.
Okay.
But just as it was written, I had concerns.
Okay. And so, I mean, it's important that we don't discount that because any criminologist will tell you that racial profiling is real.
Yes, ma'am.
There's a book out there called Driving While Black. It's something that should be looked at, and the data supports racial profiling. It's real, and it's an issue that we need to deal with. In regards to something else I saw. Explain how, because you mentioned collective bargaining review, explain how some of this stuff would either impede what's established. Go into that a little bit for me.
Okay, we have in the, both the enabling statutes that create local control and in our collective bargaining agreement, we have an area that we call investigative rights. And in the area of investigative rights, it talks about the due process rights of police officers who've been accused of rules violations, okay? So remember, we're not talking about criminal violations, we're talking about rules violations. There are very specific procedures that have to be followed, and a number of the suggestions that we have, particularly regarding subpoena power or the presence in interviews and that sort of thing, would impede or affect the investigative rights part. So we have a statutory creation of these investigative rights. You have your own Civil Service Commission's rules regarding these rights. We've just gone through a process of renegotiating our collective bargaining agreement, which I've been a part of both in the original one and now, okay? And that has been a big part of what we've talked about, is what is due process. And so these things that I'm talking about that I've been concerned with regarding how interviews are conducted, who has a right to be present, who can be interviewed, who can't, all of those things affect the investigative rights part of both the collective bargaining agreement and 84.335, which is the statute that creates local control.
And, you know, I noticed you've made a lot of reference to local control and just the statutes and issues of law. And I think it's good to know the law, but I mean, I think we can agree that just because something has necessarily been law doesn't always mean it has been fair to everybody. Right. And so when your point of reference is always what law says and what statute says, I mean, we're in a terrible place in this city, and just because something has been deemed lawful doesn't mean it's right, because that's why we are where we are today with a lot of things. And of course, I'm not here to try to debunk the certain factions of the system. I have no desire to micromanage the police department in any capacity, but I just think that our point shouldn't be, okay, well, this is legal, so we're doing it. And this all goes back to what my concerns are with us as a board and what our real duties are in regards to local control, because it seems like we're still a little bit unsure, especially when, people stand before us and it's quick to say what we can't do, what we can't do. And I think we need to, I know this was first, but I think we definitely need to focus on the next step, which clearly defines what our role is via public safety and local control, because some stuff is crossed. And just in general, as a comment, it's my desire that we do something. I don't think this thing should be attached with 1,000 amendments. I think we need to do something. The people are counting on us to do something, and let's do it to where it protects the rights of everybody. It shouldn't be just one-sided, pro-police, or it shouldn't be so loosely that, it impedes, our processes that are already in place. I just think that we need to focus on do what we need to do, and that's what the people elected us to do, and do what's right and in the best interest of them. And I don't have any more comments.
Okay. Alderman Carter.
Thank you. Thanks, Mr. Chairman. First question that I have is about your definition of your independent inquiry.
You got to speak into the mic.
First question I have, can you hear me?
Yes, sir.
First question I have is about your definition of a independent inquiry, and what was the reason to change the definition that we had? Oh, I'm
They
sorry.
still
What,
can't hear.
what was the reason to change the definition that we had in the regular bill 208 versus yours? Because yours, the only thing that it says is that we can inquire about the IAD investigation and not basically conduct our own. And is it a legal reason why?
Yes, sir. It's for the reasons that I've stated regarding the investigative rights. But your original definition says that you can request the attendance of complainants, witnesses, and employees of the department at interviews, access under reasonable terms, physical evidence, and otherwise investigate the circumstances. So what it's doing there is that you're actually calling people, in theory, at least according to your definition, to testify before you as a committee. Under any circumstance, I don't think that's what you intended, but again, that's the way it's written. And so again, that runs afoul of the investigative rights that I've been talking about.
Okay. And I believe you mentioned, and I'm not sure where, because I was...
You didn't have your copy?
Yeah, I didn't have my copy, but the education requirement that you wanted in there, I think it was at least an associate's degree, right?
Yes, sir.
And what was the reasoning for that?
That we require that of police officers. That's on page 5.
Okay.
That we require that of members of the department itself to have that. And so
Okay.
we thought having that as a threshold would be appropriate. Again, I'm not wed to that idea. I think
Okay.
experience can overcome an educational lack, because
Right.
my grandfather had an 8th grade education, and my grandfather was the smartest man I know. So, again, you don't have to have a college degree.
Okay, all right, yeah, I was going to say, because we don't have to have,
No.
education to sit on this board of aldermen, and we write tons of laws and ordinances for the city, so that was something that I didn't agree with you on. I did agree with the age change. I believe you said 21, am I correct?
Yeah, I said 21. But
Okay.
again, I like 25 better.
Yeah. And just some of the comments that you said, I think you mentioned that you would also want to take into account the things that the people posted on social media, Facebook, on Twitter,
Yes,
and
sir.
other things. Do we do that for officers before and during their employment
Yes,
on the
sir.
force?
Yes, sir.
Is it, do we catch up a lot of officers for stuff
Yes,
that they
sir.
say?
Yes, sir. And if you've been paying attention, as I know you have, and I don't mean to be flip, but you saw officers, not from the St. Louis Metropolitan Police Department, but officers in St. Louis County and other places who, after the Ferguson incidents, published things online that were awful, and they were disciplined as a consequence. We have a social media policy. That policy is enforced both in the hiring process and in the employment process.
Right. I believe that when the young man was killed, Kajin Powell, they then brought up some of the stuff that that officer had said on social media, and it was a big deal. I'm not exactly what he said. I'm not exactly sure what he said, and I can't recall, but I know that it was some pretty interesting remarks regarding blacks. And so that's why I asked, do we look at that even after they're hired?
Yes, sir.
Okay. What else? I'm pretty sure that a majority of my questions have been asked by either Craig or Antonio. So, just a quick comment. What it seems to me, it seems like just from listening to the questions that you are kind of opposed to the CLB, basically getting all of the information through questioning and interviews of an independent investigation. That's just from what I see. And you basically said yourself that you wouldn't recommend any of your clients to come and talk to the CLB board, and I think that's an issue.
I want to make it clear, I am not opposed to the CRB having all the information. I think they should have all the information. I think they will get all the information in the process that I've set out. That's number one. Number two, in terms of coming before this board, if it's not a disciplinary board, why would I ever be before it? I don't anticipate, as it's written, that I would ever be in front of the board, one way or another. That's not the way it's structured in any way, shape, or form. But could there be times? Sure. And again, to make the assumption that that somehow indicates an objection to this board, I don't object to this board.
Right, but do you agree that the only way that this board can have power and basically have folks come before us is with that subpoena
I don't.
issue?
I don't. I don't believe that
So why
at
would
all.
anyone come or give us any information?
Because Internal Affairs is going to do their investigation. Now, people may decide that they don't want to cooperate with Internal Affairs or with anyone else, and that's a problem that we've faced and we will continue to face. There are going to be people who don't want to cooperate in criminal prosecutions. They don't want to be involved, or they're afraid. There's 1,000 reasons why people won't. You won't cure that with subpoena power. So again, I think that you absolutely have a right to all this information. I want you to have all this information, but I think you will get all this information from the internal investigation. And the truth of the matter is, if you enact the bill without subpoena power, and you get into this and you're 2 years down the road and you think there's impediments, then you certainly can attempt to amend it. What I'm doing today and what I'm attempting to accomplish here is that we can do a lot if we do it together. We can accomplish a great deal. If we can agree on a form and go forward together with that form, it may or may not work, but at least we'll know. Rather than impose a form that is doomed to failure, and again, the reason I'm pointing out the legal issues is because I think there are many, all right? And we can spend lots of time in a courtroom where we can spend thousands of dollars. Is that really useful to the city or to the association? It's not. It is useful to try and come to some understanding. That's why I'm here. So again, I don't oppose the idea of a board. I want you to have the information. That's what I'm trying to do.
All right. And for my last question, I think you mentioned also that you wanted the officers' names and things to remain anonymous,
Right.
But you also wanted the actual person who filed the complaint. That would be public record.
No,
too?
sir. That would be part of the internal file. If I come in and I sign a complaint, that's closed record too. I don't disclose the name of the complainant. That's never happened in my 30 years of representing officers. We don't disclose that unless it's in a criminal case. Now, again, if there's a criminal investigation under 610, I can't protect the police report. I can't protect the officer's name there either.
Yeah, because I think that would hold a lot of people back from filing a complaint.
I agree.
You know,
I agree. And if,
scared of retaliation from officers and.
sure. And again, or from their neighbors or whatever it is. I mean, they just don't want to do it. They don't want it out there. I think you have to respect that. But that's a two-way street. You have to do that with the policemen too.
Right. All right. Thanks.
Thank you.
Alderwoman Ingracia.
No questions.
Alderwoman Green.
No questions.
I have a couple of questions. First off, with the social media policy that the police department currently has, are officers required to turn over all of their account information, their pseudonyms that they use?
Yes, ma'am. They have to identify what they use as their handles. I don't know all the words, but I have children who do. They have to give everything that would indicate who and what. That's both in the hiring process and then within. Now, you and I both know that that can be changed in a moment, but I hesitate to use the word surveillance, but those things are watched, and if it comes to the attention of someone that, a member of the department, and it might not be that they identify themselves as members of the department, but it might be something where, you know, for whatever reason, they've done something that would suggest they're a member of the department, that becomes the subject of investigation.
And then who monitors that? And who keeps track of that information?
Which part of the information?
Of what people are posting, or if there's any kind of
Well,
something
there
they
is-
should be posting?
There is within the department units, like the intelligence division, which monitors generally things like that, okay? So again, they don't troll the various Facebook pages and that sort of thing of officers who are out there once they've been hired, okay? Now, the hiring process is different, though, because once you've been hired, or at the point where you're being hired, they do all of that. They do all of those searches. Once you've been hired, it's a little bit more passive. If it comes to somebody's attention, then it gets passed up the line of command and it goes to Internal Affairs for investigation.
Okay. And then the second question I have is, in the first bill that was presented, there is no explicit mention of subpoena power within that bill.
Right.
But is it your interpretation that by saying that it has investigative power, that it is inherently giving that subpoena power? I'm trying to understand your argument
No,
there.
when you have situations where you're saying you can compel, in the first bill, when you can compel people to attend interviews and that sort of thing, the only way you can compel them is by subpoena. So I think there is sort of the argument that inherently it generates that, it means that. I want to make sure that it's clear that you can't, by implication, create subpoena power. So that's my argument. The way you've structured the provisions, like under monitoring, where I've had the biggest issues regarding how it's structured, that allows the board to compel the presence of witnesses, and you can decide when these interviews are going to take place and the manner and all that sort of thing. That suggests subpoena power.
Okay.
Subpoena power.
So then, knowing that, if the current bill if that language were to be kept, then do you foresee, litigation on that front?
I do, and that only makes the lawyers wealthy.
Okay. No more questions, thank you.
Thank you.
Okay, then. I believe that completes all the questioning of members of the committee. We thank you for coming before the board.
Thank you, Chairman Kennedy. I appreciate the opportunity to be here.
Okay, then. We wanted to have a representative from the coalition come forward now and address the committee. Then after that, we will take a break and then return to discuss next steps from there. So we have, you would identify yourself. We have Ms. Jamala Rogers. Oh, we need to, before you get started, they need to switch tapes.
Come with highlighters. Are you going to use your highlighter?
You can.
Okay. Because I'm trying to keep my comments different.
Thank you. You may begin. Please identify yourself and then any response or thoughts you had in relationship to the testimony.
My name is Jamala Rogers. I'm one of the co-chairs of the Coalition Against Police Crimes and Repression. It is a group that nearly 15 years ago, when we embarked on the issue of local control, about 100 groups and individuals signed off on that campaign to bring about accountability and local control to the citizens of St. Louis. So it's not just me, it's a really broad coalition that's both interracial, intergenerational, and based on people from lots of different backgrounds who want to bring civility to the city of St. Louis. I think it's fitting that this hearing is on the 6th-month anniversary of the Mike Brown shooting, because it needs to remind us of where we are and where we've come from and where we need to go. Mike Brown was a young African-American male that was unarmed but shot down by a Ferguson police officer. The response to that shooting was based upon years of repressive policies and behaviors of police, but also the insensitivity and indifference of civic government and faith leaders towards the endemic problems of poverty, race, poor schools. So when the young protesters came up with the slogan, "The whole damn system is guilty as hell," it was based on years of evidence that showed that. And as we saw at the public hearing a couple of weeks ago, that there was professed distrust of not only the St. Louis Police Department, but Mayor Slay as well. And so those are the voices that we've been hearing over the years, and as we tried to craft this legislation, we had them in mind. So the whole nation has their eyes on St. Louis since August 9th, no doubt about it. I was in the room for the public hearing right over here. It was very different when I saw the spectacle on TV as it was being projected across the nation. So it was very shameful and embarrassing. And this is not the Coalition Against Police Crimes view, this is my view. I think Jeff Reuter owes an apology, a public apology to this body, and particularly to the chair, for that kind of behavior. But it's exactly the kind of behavior that people have been talking about for many years. The changes of the Police Officers Association are troubling, to say the least. First of all, I have to say in response to Mr. Brundrager's response that they've been a collaborator, we have not found that to be the case. Early on, we reached out to them around state legislature, around local control, and we found that they reneged on certain commitments. And even as we had done all the work for local control, and the people of St. Louis, by referendum, said that 70% of them wanted local control of their police department. When it was evident that it was going to happen, It was then that the St. Louis Police Officers Association got in front of the Coalition Against Police Crimes and Repression to put a ballot initiative. That was not in concert with us, despite the years of work that we had done. That was in collaboration with the mayor and the billionaire that funded that ballot initiative. So I don't see them, and neither does the coalition, as good partners, good collaborators as it relates to this. And even in terms of what they brought forward today, I mean, you all just got that last night or today. We would have liked to seen it also before then to see if there was any kind of unity on any of those issues. So that's problematic, and I think that's been the case for a while. One of the things that I think the attorney for representing the St. Louis Police Association kept saying is that they're for civilian oversight. But yet, most of the most substantive issues and elements of police accountability they were opposed to or were undermining. And so I just think that's disingenuous to say on the surface, yes, we all for it, but then you start to undercut all of the elements that are going to make it strong or to limit the participation, the full participation of board members. So some of the interpretation of the way that the original board bill read, Board Bill 208, which is the board bill that the coalition supports, some of that interpretation was I think, way overreaching by the attorney, and I think that's expected because, as you said, he was representing a particular body. But when I think about trying to make the COB members set them to the same standard as police officers, that's very problematic. I mean, we are not trying to, and some of you already pointed out the contradictions. Other boards don't even have the kind of high standard where people have to have degrees, have to go through all these different hoops, which for me sounds like those are hoops that are put in place to keep certain people from being able to participate. We want full participation. We don't think they should have the same criteria as police officers. These are unpaid volunteer workers. They are not required to carry guns or use them, so we can't hold them to that kind of high standard, and I think that's unfair. I do want to also speak to the issue of age. We were very intentional about putting 18 years old because those young people, I think Alderwoman Hubbard said, have a unique experience with the police department, a unique perception about what's going on with them, and so we started at the bottom with 18 and up. And I'm looking at this board here, and there's at least 3 of you all that I've known since you were teenagers. One of them you since 14 years old. I think that you all would have been quite capable of sitting on a board like this. Whether or not you would have been willing to do that is another question. I think at 18, I would have been capable of doing this. I work with young people all over the city. I know many of them would be capable of serving on this board. The other thing that seems to be missing is that we're not looking for everything to be in one person. It's the collective experience, skills, talents of the entire board that we're trying to augment and make as strong as possible. There are requirements of the board of all the people that they know how to read budgets or they have some legal expertise, but that doesn't require them to have legal degrees or a CPA. So it just seems like to me that the standards that are being promoted by the St. Louis Police Department really is going to limit people's participation. Some of the issues that the attorney spoke to are also addressed in the ethics policy that's part of the bill, or it will be written, and so we're not so much concerned about that. The thing that I think we are concerned about is officers not testifying. I mean, what's the point? Because I'm thinking about a scenario where if an officer does not testify and all of the witnesses that have been interviewed implicate that officer on some level and they draw conclusions based on that without that officer's testimony, and that person is not comfortable or disagrees with that, then what's the recourse? So I think I see all kinds of problems with not in good faith that they're going to participate in the process, even though they're for accountability, they're for transparency, they're for all of the things that the civilian oversight represents, but yet the very issue of police coming forward to tell their stories somehow is going to be problematic. We have, over the years, as I said, we've been working on civilian oversight for 12 years. And we've been all over the country looking at what boards work, why they work, how they work. And the four things that keep coming up is staffing and funding, subpoena power, and independence from political meddling. So that means it's far away from the hands of the police chief, whoever it is, from the mayor, whoever that person is. You want that board to feel like there's not going to be that kind of influence on them in terms of their decision, that they would always have to be wondering, what does the police think about this? What does the mayor think about this? And so we want them to be as independent as possible, even if it means physically being independent, but certainly that they have some political free will, that they don't have to worry about what a police officers association is going to do and say and how it's going to affect them. I want to also say that one of the reasons that we are here today talking about civilian oversight is because of not just the resistance of police officers or the police department to be accountable and transparent, but total resistance. I mean, we've already heard that if this bill passes with civilian power, there's going to be a work stoppage. I mean, I don't think that represents the true spirit of cooperation when you're talking about a bill like this. The attorney also spoke to, he gave an example about the World Series tickets. Many of y'all might have forgotten that there were police officers who stole World Series tickets out of the police evidence room and utilized them. And so there was a suit by a regular citizen to get the evidence and documents, and that struggle has been going on for 8 years. There's already been 2 courts that have supported the police turning over those documents, and yet they keep appealing. So not only is this a misuse of time and resources of the city of St. Louis, it is not in good faith. What's the problem with turning over that evidence? And let's clear that up and move on. So that kind of resistance is going on at all levels, and I think the police department needs to be coming with a little bit more humility about what they want to do and can do and should do, because again, we're at this point now is because all that has gone before us, and because the process that has been set up by the Internal Affairs Department has not been open to citizens, and certainly once citizens go through all the hoops, intimidation, bullying to file a complaint, then rarely are those complaints sustained. So that's what this bill is all about, and I would hope that the last-minute efforts of the St. Louis Police Officers Association to derail Board Bill 208 is ignored, and that we proceed on with what we have been dealing with for the last month and a half. Again, I want to say the eyes of the world are upon us, that the phenomenon of police violence is not just here in St. Louis, it's across the country. We've already been contacted by people in other cities saying, we want to see what happens with your civilian oversight board, because we want to either revisit ours, restore it, strengthen it. And so we want to make sure that we have the best possible bill to give to not just St. Louis or North County, but to the nation. So we have a chance right now to lead. We haven't always done that in the way that young people have said so. And we want to have the most effective civilian oversight bill that we can get. And we know that the implementation is going to be a rocky at first because there's stuff that we need to work out. But by the time we come to the first anniversary of the Mike Brown tragedy, we need to be able to say, we've passed the bill, we're moving forward so that there's not a Ferguson uprising that comes to a ward near you. Thank you.
Any questions from members of the committee? Alderman Schmidt?
I do not. I appreciate your comments. And I know that you've worked hard on this for a long period of time. I don't always agree with the name of the organization, but I understand your purpose. Thank you.
And remember, it's against police crimes, not police, because we have police that support what we're doing.
Okay. Alderman Boyd, any question?
Yeah, I just have a comment. I would tend to want to agree with you on the age requirement. On one hand, you're looking for maturity to sit on certain boards. You know, the Board of Aldermen, 25, state reps, 25, state senators are a certain age requirement. However, you know, being someone who has served in the military at the age of 18 and who would be able to go off to war and maybe by the age of 20 become a sergeant and responsible for 20 to 25 young men and women's lives, you have to be prepared to make good decisions because people's lives are in your hand. But it reminds me, just kind of thought about sitting on a jury. And if you're sitting on a jury at the age of 18, somebody's life is in your hands. So I would think that the state would suggest that 18 years old makes you a responsible person to make a decision that impacts somebody's life. So that's all.
Alderman French?
I want to thank you. I appreciate all the work you've done on this issue for many years. It really has gotten us to this point. The issue of the age requirement, in the proposal I brought up last week about raising the age requirement, that was done also with raising the power and authority of the board. And so if the power and authority of the board is not increased, then I'd be fine with it staying at 18. So that's one thing. As far as in your research and experience looking at other civilian oversight boards and civilian review boards across the country, how have you seen subpoena power used in other cities? Do you find that it is something that these civilian oversight boards must rely upon very often to get these, get the information required, or is it something rarely used?
Actually, it's something that's rarely used, but in some cases, people have that to rely on if necessary. But if you have a process where you have board members that are a part of the interview, in the investigative process, where they're seeing what's happening, they're looking at the tapes, all of that, you may not need to compel any other evidence. But if not, if the police department is not forthcoming, or anybody else with the evidence that you need to make a clear conclusion, then you have that power at your fingertips. But I think for the most part, it's not used, because there's been cooperation in the investigative process where you're getting all the information that you need.
What about the ability to ask questions of not only the accused officer, but just any member of the police department who may be a witness or just have some useful information? How has that worked in other cities, and do you think that's necessary?
I think most people are aware of the Garrity rule, and so people are mindful of that, but there's still whatever the realm of possibility is of asking questions, keep it in mind, whatever the statute is, whatever the city charter says, they've been able to ask those questions. And, you know, just let me say that I'm hoping that we don't have to use force to get people to comply. And I understand that the officers have their rights. I mean, the Coalition for Police Crime, were also ones that helped to promote bargaining rights for officers, because we are a labor-friendly organization. But at the same time, if we're all in this together, then there's certain things that you really want to show good faith on, and that every time that we turn around, we're not having to pull evidence, pull witnesses, take people to court. I mean, that's going to totally, you know, derail the effectiveness of this board. And I think, as many of you all have said, people will not want to use it if those things are not in place, if there's not going to be cooperation.
Thank you. That's all I have.
Alderman Vaccaro, any questions?
Actually, a couple. So what cities have they used subpoena power in? You said you know of some.
John, you
Well, I
remember
thought
the
you knew.
specific ones?
Because I was going to look it up, just I'm curious.
A little louder. Los Angeles County, and which one? New York. Cincinnati. Baltimore. So some people know that. I think if you Google it, you could probably see it.
Which ones have used subpoena power? I'm just curious. I agree with everybody on the education thing. I don't know what the issue with drug testing. Maybe we need to do an ordinance where all elected officials get drug tested. I'll go right now.
Including police
I guarantee
officers?
you, I have no,
Yes.
I don't do drugs.
Yeah.
I don't even drink or smoke cigarettes or drink coffee. I did today to keep awake, but I'd be all for that. But the rest of mine are more comments, so I'll keep it to the end. But I was just curious so I can get a minute to look that up.
Okay. Alderman Arnowitz, any questions?
Thank you, Mr. Chairman. Ms. Rogers, I know you've been a hard worker for a long time, and I really appreciate your input. And I think hopefully eventually we're going to get to a happy medium with everyone. So, and I really do appreciate all the work you do. You're out there all the time, and you don't just sit by at home, and you try to bring the goodness in the community at the same time. Thank you.
Thank you.
Alderwoman Hubbard?
No questions.
Alderman Carter?
No questions. I just want to thank you for all of your hard work on this. I know that you've been working on this for a long time, and thank you. Thanks for everything that you do.
You're welcome.
Alderwoman Ingracia?
I also don't have questions, but thank you for working on this issue and a variety of others that are important to our community.
Thank you.
Alderwoman Green?
I also do not have any questions, but really would like to thank you, and also the, you've really gone, I think, above and beyond trying to educate the broader community about what is in this bill and not in this bill, and what it could mean, and I think education is so important about issues regarding this, so I really appreciate that. Thank you.
And if there's no other questions, again, we thank you for coming before us. We will take a 20-minute break. 20. Yes, that's the idea. Take a 20-minute lunch, 20-minute break and return. Thank you.